probably a golden period for bond traders. It's probably a golden period for creditors in the Indian market. The Bankruptcy Committee has submitted its recommendations and it is on the Finance Ministry's website. The highlights of the code is that there should be an insolvency regulator and that unsecured creditors can also drag companies if there is a default. We are being joined by one of the authors of the code of the recommendations, Mr. M.R. Umarji. He's former chief legal advisor at the Indian Banks Association and of course a very respected legal luminary. Also joined by Mritunjay Kapur, the National Head of Risk Consulting at KPMG. Gentlemen, good morning. Thank you very much for joining us. Mr. Umarji, first lay out the main features for us. How is the world view, the recommendations of the committee different from the current situation?
See, the main issue involved is the trigger for filing a bankruptcy petition. An insolvency resolution petition to be filed on a default committed by the borrower. Now, so if I commit a default today, the insolvency petition can be filed tomorrow. And there is the regulator is supposed to be regulating the insolvency practitioners and information utilities. Now these information utilities are proposed to be set up who will collect data on all financial contracts and the dates for repayment of various loans taken from the banks and other creditors. And any default will also be recorded by the information utility. So when the insolvency petition is filed, there will be a verification from the information utility whether a default has been committed or not. And once it is confirmed that there is a default, then an order for appointment of an interim insolvency practitioner will be passed, who will then be required to take possession of all the assets, and the process of insolvency resolution will start.
Okay.
Now, you see, if you compare this with the provisions of the SARFAESI Act, the trigger is classification of the account as non-performing asset, which is after 90 days, and then the process of enforcement of security starts. But here it is immediately after default.
All right, let's get Mritunjay Kapur.
So the object is that...
Yeah, go ahead, sir.
Go ahead.
The object is to ensure that the payments are made on due dates and no defaults are committed. If you commit a default, there is a probability of a petition being filed against you, and to avoid that insolvency order to be passed against you, the only option is to make payment of the defaulted loan.
So obviously, Mr. Umarji, therefore, it's not just banks, it will be even unsecured creditors or even employees who can file for insolvency?
It is there is operational creditors, that is persons who are supplying goods and services to the company, and other persons who are having claims against the company. They can also file a petition. The only thing is that the process for establishing that their claim is an undisputed claim on which the company is liable to pay involves a little process which has been prescribed by the code. And after satisfying that there is a claim and it is undisputed, the process of insolvency will start.
Okay, well, just stay on, gentlemen. We need to address the markets as well. The Nifty has slipped below that 8,000 mark. Once again, it's the second time this week that the Nifty is below the 8,000 mark. And there's something going wrong with the Bank Nifty. That's down more than 1% now. Just pull up the Bank Nifty for you, the intraday chart. It's just hanging on to 17,000 by the skin of its teeth. Yes Bank, Axis Bank are all taking a big knock. But not just that, mid-caps are now underperforming as well. So all of your names, you know, Bata, Ashok Leyland, and Dish TV are all coming in for intense selling pressure. So today is not looking good. Nifty now below the 8,000 mark. But let's get the other gentlemen into our discussion as well on the bankruptcy code. Mritunjay Kapur, the National Head of Risk Consulting at KPMG, is also with us. Mritunjay, morning. Will these new insolvency rules be effective enough to facilitate, easy and time-bound closure of businesses?
So I think, it's an interesting question, and I think the fact that the trigger is changed and you can essentially file for insolvency on the next day of the default is a big factor. And if you look at some of the statistics, I think any change that we're bringing in will have a positive improvement. Today, India is ranked at 136 out of 189 odd countries in terms of ease of doing business when it comes to filing for insolvency. And I think we take somewhere around 4.3 years to close out on insolvency cases as compared to around 1.5 years in the OECD countries. And similarly, in terms of the recovery, I think that's an important factor. The estimates say that it's just 20% of the non-performing assets of the bad loans that we are able to recover, as opposed to over 80% globally. So I think this change will facilitate a lot of, get in a lot of difference. It's been almost 2 decades that this has been on the cards. So certainly the industry is looking forward to the real ease of actually exiting or recovering loans as part of the ease of doing business.
Yep. Mr. Umarji, this also calls for setting up of a lot of intermediaries. You spoke about the information utilities. Would they be set up by the government? They would be public sector or state-owned entities, will they be? Also the insolvency practitioner, and then the company law tribunals, the entire administration, the substructure. A lot of organizations have to be, entities have to be set up, no?
No, the insolvency practitioners are going to be the chartered accountants, company secretaries, and cost accountants and practicing lawyers will be able to practice as insolvency practitioners. And they will be initially subjected to regulation by their respective association of their own profession, and overall regulation will be that of the new regulator which is proposed to be set up. And the other entities which are going to be set up, as far as the tribunals themselves are concerned, national company law tribunals are to be set up under the new Companies Act 2013. The Supreme Court has already declared this NCLT setup as constitutionally valid, subject to certain changes suggested in the Companies Act. The whole process is on, and after those amendments are carried out, the new company law tribunals will be set up by the Ministry of Corporate Affairs, and the system will become operative.
Okay. Well, a final question to you, sir. Assuming the law gets passed in the winter session, how much time before it actually becomes effective? Because the tribunals have to be set up, the information utilities have to be set up, the insolvency practitioners have to be empaneled. How much time before we actually get the new regime in place actually working?
Yeah, if the bill is passed, it may take about a year's time to set up this entire system.
Okay. Go ahead, sir.
It will take about a year's time to set up this entire, you will have to frame regulations under the Act, you will have to give permissions to various practitioners to function as insolvency practitioners. You will have to set up information utilities, which will be private sector companies. They are not going to be public sector. It may happen that there are certain existing credit information companies which are already operating in the country. They may also be given this additional responsibility as an information utility, or new information utilities may be set up. And the whole system, when it is placed, the law should become operative.
All right. We leave it at that, gentlemen. We need to